Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 39th lecture, to which I am going to discuss. The title of today's presentation is International Norms and its impact on Indian criminal justice system. So, in this lecture, we will try to understand that what are the international norms, parameters on criminal justice system, whether Indian criminal justice system has adopted all those parameters, norms of international norms has been adopted or not. So, in this lecture we will try to understand that what is international norms on criminal justice system, and then after we will try to make a comparison between international norms on criminal justice system and national norms, means what are the norms on criminal justice system which we have adopted, which Indian criminal justice system has adopted. So you can see on your screen that I have referred UDHR because any lecture pertaining to human right would not be complete unless UDHR is referred, unless International Bill of Rights is referred, unless this international covenant on civil and political right is concerned. So without referring these international instruments, lecture on human right would be incomplete. So I have referred this UDHR 1948. You can see on your screen I have referred three important international documents. First is UDHR 1948 and second is ICCPR, that three important international instrument, UDHR, ICCPR and ICSECR. These three international instruments is referred as International Bill of Rights. And on the other hand, I have referred all human beings are born equal. It is specifically mentioned in Article 1 of UDHR 1948 that all human beings are equal. So we have adopted this concept under Article 14 of the Indian Constitution. You all might be knowing that provision. Every person has right to live with human dignity. It is stated in Article 3 of this UDHR. So this every person has right to live with human dignity is stated in this article, and we have adopted the same provision under Article 21 of the Indian Constitution. So Article 21 of the Indian Constitution says that no person shall be deprived of his life or personal liberty except procedure established by law. So Indian Constitution of India, being supreme law of the land itself, has duly recognized this right to life as a fundamental right under Article 21 of the Indian Constitution. And this UDHR 1948 has paid due respect this right to live with human dignity under Article 3. Now come to this UDHR and its impact on criminal justice system. As I said, Universal Declaration of Human Rights is considered as first international document, first declaration of human rights across the globe, where member states have given their consent to pay due respect to the rights to those human rights stated in UDHR 1948. And India too has adopted almost all the human rights stated in UDHR 1948. Article 5 of UDHR is very important, which I would like to mention. You see, Article 5 talks about protection against illegal arrest. I have written, you can see on your screen, and then I will explain it. Article 5 UDHR 1948, that is protection against unlawful arrest, inhuman treatment, protection against inhuman treatment, cruel punishment. You see, this Article 5 talks about protection against cruel punishment, inhuman treatment. So Article 5 is very important so far as protection against illegal arrest is concerned, cruel punishment, inhuman treatment, and the same rights, protections have been duly recognized by our judicial system, by our Supreme Court, Sunil Batra versus Delhi administration. So I will discuss that case in detail. Here you need to understand that how this Article 5 has affected, how Article 5 of UDHR has influenced Indian criminal justice system, whether Indian criminal justice system has incorporated all these provisions or not. So we will try to understand these protections in our legal system under Indian criminal jurisprudence. Right to fair trial is essential, is an important right. You see, Article 10 of UDHR 1948 talks about right to fair trial. So right to fair trial is also a human right provided in Article 10 of UDHR 1948. Every person is entitled to be tried fairly by competent authority. And what are essential components, what are basic requirements for fair trial, I will discuss one by one. So you see, Article 5 and Article 10 of UDHR, these are the international parameters, international norms on criminal justice system. Accused has right to be tried fairly. Accused has right to be treated humanely. Accused has right not to punish, it means no cruel punishment can be given, no harsh punishment can be given to the accused. So these are the basic principles of criminal jurisprudence, and which we have adopted in our criminal justice system, which India has adopted under Indian criminal justice system. And we will try to understand this UDHR and Indian criminal justice system. You see, the title of this slide makes it clear that Indian criminal justice system would be examined in the light of UDHR, Universal Declaration of Human Rights. So we will try to understand that what are the Universal Declaration of Human Rights, how that declaration has affected Indian criminal justice system. As I said, Article 5, I have mentioned one side. Article 5 talks about right against unlawful arrest, inhuman treatment, Article 5, and that provision has been incorporated under Indian Constitution. You see, Article 22 talks about right against illegal arrest, right to be produced within 24 hours before the magistrate. So this Article 22, which talks about protection against illegal arrest, right to be produced within 24 hours from the time of arrest before magistrate, and this protection was duly recognized. Protection provided in Article 5 of the UDHR was duly recognized in Sunil Batra case, Sunil Batra versus Delhi Administration, AIR 1981 Supreme Court. So you see, this Constitution of India provides a special kind of protection to all the accused, that arrested person has right to know the ground of arrest. That is essential component of fair trial. Without informing the ground of arrest, without informing the ground of allegations, if trial is conducted, that trial cannot be treated as fair trial. So right against illegal arrest, a right to be produced within 24 hours before the magistrate, that is a guarantee provided in Article 22. So we can say that Article 22 and Article 5 both have been effective, or both, you can say that Article 22 of the Indian Constitution is in the tune with Article 5 of UDHR. So I have no hesitation to say that Indian criminal justice system has paid due recognition to Article 5 of this UDHR. So this is very essential, that Supreme Court in Sunil Batra versus Delhi Administration held that you all might be knowing that Sunil Batra had written a letter to to a judge of Supreme Court by highlighting the plight of inmates of prison. So in that letter he had highlighted the sorry state of affairs of Tihar prison, and when inquiry was conducted, all the allegations made by Sunil Batra was found correct, and on that basis Supreme Court for the first time held that protection against inhuman treatment, that is a guarantee, and it would be violation of Article 21 of the Indian Constitution, where accused prisoners are harassed, prisoners are tortured, harassed in prison. So it is the responsibility of prison authorities to protect the life and liberty of prisoners in prison also, safety of prisoners also. So prisoners, they do not lose their rights merely because they have become accused. Because of that presumption, you all might be knowing that every person is presumed to be innocent unless his guilt is proved before the court of law. Since under trial prisoners are still facing their trial and still innocent unless his guilt is proved before the court of law, so they are entitled to avail all the benefits which they can avail from the state. So this kind of observation was made by Supreme Court in Sunil Batra case. Now let us understand another important parameter on criminal justice system, that is right to fair trial. You can see on your screen, I have referred this right to fair trial, UDHR versus Indian criminal justice system. I have just written this just to explain you, just so that you can understand all the things. I have mentioned Article 10 of UDHR 1948, which talks about right to fair trial, open court, and Section 209 CRPC 1973. Section 209 CRPC, I have referred it with a specific purpose. It talks about right to know ground of arrest, right to know accusations, allegations, right to get copy of FIR free of cost. This is free of cost. And this charge sheet, right? You see charge sheet also, list of prosecution witness. These are the essential document which must be provided to the accused at the time of trial. So every accused has right to know the ground of allegation, on what grounds court is going to prosecute and convict him. So for that purpose, accused is entitled to get copy of FIR free of cost, list of prosecution witnesses free of cost, and these are the certain requirements to consider that trial fair trial. So without providing these documents to the accused, trial would not be treated as fair trial. So it is the duty of fair trial to ensure that at the time when trial begins, before beginning of the trial, all the relevant documents, copy of FIR, charge sheet, and list of prosecution witnesses, all these relevant documents must have been supplied to the accused. Without ensuring all these documents by the trial court cannot start the trial. If trial is started by the trial court without giving all these relevant documents, then accused can file a petition in higher court on the ground that he was not supplied that document, and in the absence of that relevant document, accused could not defend himself effectively. Since right to defend himself is a fundamental right to have a counsel of his own choice, that is a fundamental right. If accused is poor, then that accused has right to get free legal aid from the government, and it is the duty of government, it is the duty of court to provide advocate free of cost. So all these formalities must be done by trial court at the time of trial. If any component, if any parameter is missing, then that trial cannot be treated as fair trial. You see, these are certain requirement for a fair trial, and or you can say that these are basic principles or basic features of fair trial. So a trial to be fair must have certain requirements, must be fulfilled by the trial court. And what I have said, that without providing a copy of FIR, how accused would get information that what are the allegations, on what allegation court is going to, on what ground court is going to prosecute him. So that is why supply of FIR is necessary. Second is a list of prosecution witness. So this document is very essential so that accused can prepare his defense, and he can also prepare his witness in against the prosecution witness. So that is why the list of prosecution witness is necessary. And lastly, it is also mentioned in section 273 CRPC that statement of the accused must be recorded by the trial court in his absence, in the presence of the accused. Statement of accused must be recorded in the presence of accused, not at the back of, not in the absence of accused. It would be injustice against accused if his statement is not recorded in his presence. So it's very obvious that statement must be recorded in his presence. Section 273 CRPC talks about this thing. So you see, this is the basic requirement of fair trial, which UDHR, Universal Declaration of Human Rights, has specifically guaranteed this right as a human right, and all the human beings are entitled to get fair trial by competent authority. And for fair trial, trial court, all the trial court must be open court. Open court here means a court to which people have access, where people can easily see the proceeding of the court. So that is an open court. So all the criminal courts are open court except few. There are certain exceptions where in-camera proceeding can be conducted in criminal cases, particularly in rape cases, particularly in case of sexual offences. Proceedings are conducted by trial court in camera. So people, common man, people are not allowed to access that court. People are not allowed to see the proceeding of the court. Otherwise, trial court must be open court, where people, anyone can see the proceeding of the trial court, what is actually going on. And the purpose behind this open court is, court to be open is that to maintain public confidence in justice delivery system, so that people have confidence in justice delivery system. So in order to maintain public confidence in justice delivery system, courts are open, and courts are open for all. Any person can participate in court's proceeding, judicial proceeding. Any person can go to the court and can see the proceeding, what is actually going on in the court. So this is the purpose of open court. So this is also a basic requirement of fair trial. UDHR is very clear on this point, and Indian criminal justice system has paid due respect to this provision by inserting all these requirements in the Code of Criminal Procedure, and even in new Bharatiya Nagarik Suraksha Sanhita 2023, which I will discuss in coming hours. Now I would like to highlight another aspect, principal features of fair trial. So this you can see principal features of fair trial at national and international level. I have just captioned this so that you can understand that what are principal features of fair trial at national level or international level. So I just want to explain Article 10, right to fair trial, Article 11 of presumption of innocence. This is UDHR 1948, I have already highlighted these two important components, presumption of innocence and right to fair trial. Now let us understand whether these two things have been incorporated under Indian legal system. So section 50 of CRPC, the Code of Criminal Procedure, and Article 22 of the Indian Constitution talks about this fair trial, and section 50 of the Code of Criminal Procedure says that right to know the ground of arrest. This is statutory right. This is the right provided in statute, the Code of Criminal Procedure 1973, that every arrested person has right to know the ground of arrest, on what ground that person has been arrested. If ground is not communicated by police by arresting officer to the person, then that arrest can also be treated as illegal or unlawful arrest, and protection against illegal arrest is a guarantee provided under Article 5 of UDHR. You all might be knowing, I have just referred that Article 5. So here ground of arrest is not communicated to the accused, arrest would be unlawful, and it would be against the spirit of Article 5 of UDHR 1948. So this is another important aspect of fair justice, impartial justice. This right must be protected, and section 273 CRPC, section 273 of the Code of Criminal Procedure, which talks about recording of statement in the presence of the accused. I have just referred this. So all the statement must be recorded in the presence of the accused. This is the basic requirement. Trial court to be open court. These are the basic features of fair trial. At the time of trial, trial court has to ensure section 209 of the CRPC, section 207 of the CRPC, section 209 of the CRPC Code of Criminal Procedure, section 50, section 273 CRPC, and Article 22 of the Indian Constitution. At the time of trial, trial court has to ensure that case is not coming within ambit of Article 20 clause 1, Article 20 clause 2, Article 20 clause 3. So then trial court will have to ensure this protection against self-incrimination, whether accused is pleading before the court, trial court, that he was compelled to give witness against himself, police threatened him to confess his guilt. If this kind of allegation is made by accused before the trial court, then trial court will also record that statement, and that statement will be taken on record that accused was compelled by investigating officer to confess his guilt, and it is violation of Article 20 clause 3 of the Indian Constitution. So all these things I just want to explain you that Article 20 clause 3 also protects the rights of accused. If accused is compelled by police officer to confess his guilt, it would be against the spirit of Article 20 clause 3, and just by proving the fact before the trial court, accused can take plea that he was compelled to confess his guilt, he was threatened, he was tortured, he was induced by police officer, by investigating officer to confess his guilt, so that is why he confessed his guilt. If this kind of allegation is made by accused, then obviously trial court will consider that statement as contrary to Article 20 clause 3, and it can be treated that there was violation of fundamental right guaranteed under Article 20 clause 3 of the Indian Constitution. So with this I would like to move on second slide. This right to legal aid, you can see on your screen that I have chosen this slide, right to free legal aid. You see, right to legal aid, how legal assistance can be given to an accused. At international level, I have written this, UDHR is there, Universal Declaration, right to be represented by a counsel. It is also provided in UDHR 1948. Section 303 of the CRPC talks about right to legal aid in criminal cases. You can see on your screen, right to free legal aid, section 304 CRPC, and leading case wherein Supreme Court has duly recognized right to free legal aid as a fundamental right, that is M.H. Hoscott versus State of Maharashtra, AIR 1978 Supreme Court. So I have made an attempt to give you all the informations related to legal aid. So now let us understand this concept, how right to legal aid and right to free legal aid is essential for an accused in criminal justice system. Under Indian criminal justice system, the most precious right in the hands of accused is right to get legal advice, legal assistance from the counsel, from the advocate. If accused is poor, then he must be provided counsel, he must be provided legal assistance on the cost of the government. This protection is provided in UDHR 1948, that every human being has right to be represented by his counsel. The same thing is, the similar provision is provided in the Code of Criminal Procedure 1973. Section 303 of the Code of Criminal Procedure 1973 talks about right to legal aid in criminal matters. So I am just referring section 303 CRPC, that every accused shall have right to engage his counsel at the time of trial. So every accused shall have right to have a counsel at the time of trial. When trial begins, he can take, no case can be decided without legal representation. So are you getting my point, what I am trying to say? So no case can be decided by a court without legal representation. Legal representation here means that every accused must be represented by his counsel or by his advocate before the court of law. So from that, this right to legal aid comes, and right to legal aid is a statutory right as well as fundamental right. Why it is fundamental right? Because it is provided under Article 22 of the Indian Constitution. Article 22, let me refer Article 22. Article 22 of the Indian Constitution says that every person shall have right to have a counsel. Every person shall have right to consult from his counsel or advocate of his own choice. So Article 22 makes it clear that right to consult from a lawyer or counsel, that is a fundamental right, and state shall not deny to give that protection to an accused. This is a guarantee under Article 22 of the Indian Constitution, and this is also provided under in UDHR 1948. So Section 303 CRPC also talks about that right to legal aid is a statutory right. Now come to Section 304 of the CRPC. Section 304 of the Code of Criminal Procedure says that in criminal cases, every accused who is poor, who is unable to engage his counsel or advocate due to poverty, that accused shall have right to get free legal aid free of cost. So Section 304 CRPC makes it clear that right to free legal aid is a statutory right provided under Section 304 CRPC. This right to free legal aid is a statutory right as well as fundamental right. Why I am saying that this is a fundamental right? Because Supreme Court in M.H. Hoscott versus State of Maharashtra, EIR 1978, for the first time held that right to free legal aid is essential component of Article 21 of the Indian Constitution. Right to life would be meaningless for those poor people who cannot engage counsel, who cannot engage advocate for their defense, and if they are not getting justice due to poverty, then that right to life for those poor people would be meaningless. So Supreme Court for the first time held that right to free legal aid is essential component of right to life or personal liberty. If accused due to poverty is languishing in jail for several years because he could not manage his counsel or advocate to defend himself, it would be violation of Article 21 of the Indian Constitution. So for that, Supreme Court recognized this right under Article 21 of the Indian 21. So I have highlighted judicial pronouncement, statutory provisions, constitutional provisions with regard to legal aid and free legal aid, so that you can get entire information regarding legal aid and free legal aid in criminal justice system. So this criminal justice system responsibility, burden of proof lies on accused that he is poor. He must be provided legal aid free of cost. Once that fact is established before the court that accused is poor, indigent, cannot engage his counsel due to poverty, at that very moment criminal court, trial court will have to provide advocate counsel free of cost. You might be knowing that in civil cases, the Code of Civil Procedure 1908 also talks about pauper suit, indigent suit, justice to the poor people. If a plaintiff or defendant, they are, as the case may be, if they are poor, they cannot manage counsel. So Order 33 talks about indigent suit, pauper suit. So that plaintiff or defendant who is poor must be provided legal aid free of cost. So criteria is different for under CPC and CRPC. So I wanted to correlate section 304 CRPC and order 33 CPC so that you can have complete idea about legal aid and free legal aid in civil cases as well as in criminal cases. So I think that you all have understood this concept, right to legal aid, how right to legal aid is essential for dispensation of justice. Now moving on another slide, this right to accused. You see this, I have chosen this slide, and with the help of this slide I will try to explain you that what are those rights which accused possess in under criminal justice system. UDHR 1948, Article 5, right against torture, inhuman treatment, protection against double jeopardy, self-incrimination. So I have already highlighted Article 5 in detail, that Article 5 gives a guarantee, protection against inhuman treatment, against illegal arrest, against inhuman treatment, torture. So now let us understand this concept with respect to Indian criminal justice system. Article 22, you can see on your screen, I have made an effort to explain you that Article 21 prohibits any kind of torture or inhuman treatment. Supreme Court in Prem Shankar Shukla vs. Delhi administration held that handcuffing is violation of Article 21 of the Indian Constitution. So protection against handcuffing is a guarantee, is a protection provided under Article 21 of the Indian Constitution, because it is a very degrading, it degrades the dignity of human being. So unless and until there is a possibility that accused might abscond from the police custody or from the prison, no accused should be handcuffed, no person should be put on bar fetters. So Supreme Court has already highlighted this. You see, as I told you that there are certain rights which accused can claim. The first right which I have referred, right to know the ground. Soon after the arrest, the first right which comes into picture, that is right to know the ground of arrest. Section 50 CRPC. Right to be produced within 24 hours from the time of arrest. Article 22. A right to have a counsel. Right to have a counsel, right to consult from a lawyer of his own choice. This right is a vested interest, vested right in accused. Soon after the arrest, accused has fundamental right to consult, to take legal advice from his counsel, from his advocate, as per the mandate of Article 22 of the Indian Constitution. And Supreme Court, in a leading case, Khatri versus State of Bihar, has already pointed out that under trial prisoners, arrested person can have a counsel right from the arrest until the disposal, till the conclusion of trial. Every accused has right to consult from a counsel, from advocate. So you will have to understand statutory provision, constitutional provision with regard to rights of accused, and judicial approach, view of Supreme Court on that particular point. Only then you will have complete understanding about Indian criminal justice system and rights of accused. Now come to the third important right of the accused, right to make an appeal. If accused is convicted by the trial court, he has a right to make appeal against his conviction. So right to appeal is also important right. Protection against handcuffing. This is also right to legal aid and right to free legal aid. So I think there are about 10 important rights which you all need to remember. That right to know the ground of arrest, right to know the ground of accusation, right to be produced within 24 hours from the time of arrest, right to legal aid, right to free legal aid, protection against handcuffing. The last one is right to medical aid, right to be examined by medical practitioner. So these are certain protection against self-incrimination. So these are protections available to accused. These are the certain rights which are available to the accused under criminal justice system. So I think that you all have understood all these things. Now, right of accused and right of victim of crime. So now I am going to discuss victim's right under Indian criminal justice system. So with the help of this slide, I would like to explain you that what are the rights available to victim of crime under criminal justice system. So I have just gathered some information regarding right of victim of crime. General Assembly resolution on right of victim of crime. You can see this on your screen. And this General Assembly, UN General Assembly resolution, I just want to add this one. UN General Assembly resolution on rights of victim of crime 1985. So according to that resolution, victim is also defined in that resolution. Who is victim? And I have also tried to correlate this United Nations General Assembly resolution 1985 with the Code of Criminal Procedure 1973, section 2WA of the CRPC, which talks about victim of crime, right to file a complaint or FIR. I will discuss it in detail. This victim of crime has right to file a complaint, right to lodge FIR, right to file a protest petition. You just see, you look at your screen, right to file protest petition and right to appeal. So these are certain rights which are available to the victim of crime, and I will discuss one by one. So firstly, I would like to explain you who is victim of crime. Victim of crime, according to section 2WA of the Code of Criminal Procedure 1973, the word victim of crime was defined in the year of 2008. Parliament, by Criminal Law Amendment Act 2008, has inserted this new clause, section 2WA, and by that provision, Parliament for the first time has gave a precise definition of victim of crime. According to section 2WA of the Code of Criminal Procedure 1973, victim is a person who individually or collectively suffered loss or injury caused by the offender. So this is the precise meaning of victim of crime. victim of crime has right to file a complaint. Either he or she can make a complaint to competent authority, or he or she can lodge FIR to the police station. By lodging FIR to the police station, she can or he can mobilize the police. This is the first. Second important right is right to file protest petition. Where charge sheet is not submitted, where victim of crime is not satisfied with the charge sheet, then he or she has right to file a protest petition in that very court where closure report is submitted. So this is a very precious right in the hands of victim of crime. So under Indian criminal justice system, victim was neglected earlier, but Bharatiya Nagarik Suraksha Sanhita 2023, which Parliament has recently enacted, three important legislation: Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023. So in this special legislation, Bharatiya Nagarik Suraksha Sanhita 2023, the entire emphasis is given to the protection of victim of crime and witnesses, because without providing protection to the victim of crime, without providing protection to the witness, fair trial could not be conducted. And you might have seen that in the absence of evidence or due to hostile witness, many times you might have seen that witness in criminal cases became hostile. They retract from their previous statement. So due to retraction, due to hostile witness, trial court was unable to decide the case. So for that purpose, Government of India, Ministry of Home Affairs has prepared a very good scheme for the protection of witness, victim protection, witness protection scheme 2018. In new criminal laws, section 360, Bharatiya Nagarik Suraksha Sanhita 2023 gives liberty to victim of crime to file a protest petition at the time of withdrawal of prosecution against the offender. He or she, being a victim, can file a protest petition where where government had decided to withdraw the prosecution against the offender. Earlier it was not so. This right was not given to the victim of crime in previous criminal laws. So we must be hopeful that by this new criminal laws, the things will be very clear, and victim of crime, they have got a special privilege, attention by the criminal justice system. So victim has right to get compensation if he or she has lost injury, suffer loss, or has lost his property or reputation, so he or she can get compensation also. Victim has right to make an appeal. This right is very important, because where appeal is not made by state government in case of acquittal of the accused, then victim of crime would be at liberty to make an appeal against that order, against the order of acquittal or lesser sentence. Section 372 of the Code of Criminal Procedure 1973, which I would like to mention here, that section 372 specifically talks about right of appeal to the victim of crime, where victim of crime, I am referring section 372, victim of crime shall have right to make an appeal against acquittal order or lesser sentence passed by the trial court. So earlier what happened, generally state knowingly or unknowingly could not make an appeal against lesser punishment or inadequate sentence. So victim had no say in criminal justice system. Victim had no right in the Code of Criminal Procedure 1973. Either she or he had to knock the door of High Court or Supreme Court just to file a protest petition in the court that he or she was not satisfied with that sentence or that acquittal, and it was up to the court. If court considered that he or she should be allowed to make an appeal. Only then, now this right has been given by Bharatiya Nagarik Suraksha Sanhita 2023, and in this right to the victim of crime was recognized as per the recommendation of Malimath Committee 2003. Malimath Committee for the first time recommended that victim of crime should be given liberty to make an appeal against order of acquittal or against lesser sentence. If he or she is not satisfied with the judgment of the trial court, he should be given or she should be given liberty to make an appeal. Malimath Committee had also recommended that victim of crime must be impeded in criminal proceeding code so that he or she can see the judicial proceeding, what is actually going on in the trial court, whether advocate, government counsel is representing his or her case effectively or not, so that he can raise objection whether his case is being represented properly or not, where government advocate is representing his case effectively or not. So Malimath Committee for the first time recommended that victim of crime must be equipped with all these rights, so that victim can understand that even he or she has locus in that case, or he or she has been allowed to attend that criminal proceeding where court is going to prosecute accused who has committed crime against him, against his or against the victim's relatives. So these are certain safeguards provided in this Bharatiya Nagarik Suraksha Sanhita and the Code of Criminal Procedure 1973. So I think this right of accused and right of victim of crime, with the help of these two, I will try to explain you that in previous Code of Criminal Procedure 1973, that code was accused centric. On the other hand, this new criminal law, Bharatiya Nagarik Suraksha Sanhita 2023, this is victim centric legislation. Victim centric legislation here means that this Bharatiya Nagarik Suraksha Sanhita 2023 is more lenient, has given more liberty to victim of crime to make protest petition, to file protest petition, to make an appeal, to get compensation, and victim of crime also entitled to get medical facility on the cost of the government. In few cases, victim of crimes, they are entitled to get medical facility free of cost, that is specifically provided in Bharatiya Nagarik Suraksha Sanhita 2023. The most significant provision which this BNSS 2023 has inserted, that is the protection of rights of victim of crime and protection of witness in criminal matters. It is specifically mentioned in Bharatiya Nagarik Suraksha Sanhita that state government, all the state government shall prepare a scheme for the protection of witness in coordination with central government. So state government will have to prepare a scheme for protection of witness in coordination with central government. So central government will provide sufficient fund to the state for the protection of witness, and so that fair trial would be conducted and accused can be punished by the court. So these efforts which government has made in this Bharatiya Nagarik Suraksha Sanhita 2023 is very recommendable, is very praiseworthy. It was the long awaited justice which government has done by enacting these three important legislations. If you will go through, I will suggest, if you will go through the provisions of Bharatiya Nagarik Suraksha Sanhita 2023 and Bharatiya Nyaya Sanhita 2023, you will find that these three criminal legislations are victim centric and they provide speedy justice. They talk about rights of victim of crime. Special provision, special protection has been given to victim of crime. Special protection has been given to witnesses of criminals, and severe punishment is provided for the hardcore criminal. Severe punishment has been provided for the habitual offender so that they cannot repeat the offense in future. So this is the objective of these three important legislation, which I would suggest you all to refer these three, to read these three criminal laws so that you can get entire information. So I have highlighted right of victim of crime and right of accused in detail. Supreme Court has already highlighted that even rape victims are entitled to get compensation. Bodhisattva Gautam versus Subhra Chakravarti case. Chairman Railway Board versus Chandrima Das. Chairman Railway Board versus Chandrima Das. In that case, Supreme Court for the first time held that even foreigners are entitled to get compensation from the government if government representatives have committed any wrong. Then it's government responsibility to compensate the victim of crime. So what actually happened in this case, Chairman Railway Board versus Chandrima Das, this case is also related to rape, where few Bangladeshi women were raped by rape was committed against Bangladeshi females when they were traveling from Howrah to Delhi, and the act was committed by railway employees. So when petition was filed before Supreme Court, so Supreme Court held that all the employees belong to Railway Board, so it is the liability of state, it is the liability of Railway Board to provide compensation, to compensate all those Bangladeshi female who had suffered, who against whom that offense rape was committed. So one plea which was taken by counsel that they are the foreigner, they cannot take plea, they cannot take defense of this, but Supreme Court rejected that plea and held that even foreigners are also entitled to get the benefit protection of Article 21 of the Indian Constitution. So in this way, Supreme Court has widened the scope of Article 21 of the Indian Constitution, and by expanding the horizon of Article 21 of the Indian Constitution, Supreme Court has awarded compensation in many cases, in many criminal cases, which I have referred. Chairman Railway Board versus Chandrima Das, Bodhisattva Gautam versus Subhra Chakravarti, Nilavati Behra versus State of Odisha, Ruddal Shah versus State of Bihar, Bhim Singh versus State of Jammu and Kashmir, Khatri versus State of Bihar. These are certain cases where a victim of crime has been awarded either compensation or state was directed to release them due to state negligence. Victim of crime had to remain in jail for several years. So I think I have covered each and every aspect of rights of accused and victim of crime, international and national norms on administration of criminal justice system. By referring all these judicial pronouncements, you can substantiate your argument. I think I have not left a single case which I have not discussed in this lecture with regard to rights of victim of crime or rights of accused under criminal justice system, or I have also highlighted constitutional aspect as well as statutory aspect so that you can understand entire things related to this. I also highlighted constitutional protections, Article 20 Clause 3, protection against self-incrimination, Article 21, Article 22, right to know the ground of arrest, right to be produced within 24 hours from the time of arrest, right to legal aid, right to free legal aid, and right to medical aid, right protection against handcuffing. So these rights which are available to accused, right to file a protestation, complaint, these rights are available to victim of crime. I also referred Malimat Committee in this lecture so that you can understand that what is the contribution of Malimat committee in this in criminal law reform. So if you will go through this Malimat committee or these recommendations, these provisions which I have discussed in this classroom, in this lecture, I do believe that you can get success in any examination, where if you refer all these cases, if you remember all these cases, definitely you will get success. With this, I would like to conclude this lecture. Thank you all.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that's the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.